Good morning, law officers of Lal Varghese. We are located in Dallas, Texas. We can be contacted at our email address attyl@aol.com. We can also be contacted at our WhatsApp number +1 972 556 1109. Repeating, +1 972 556 1109. Please remember, we are 12 hours behind Indian time. The best time to contact us from India is between 8 p.m. and 4 a.m. Indian time. In this episode, I'm going to discuss about the easiest way to obtain a green card provided you are eligible. If you want to check your eligibility, you have to watch our previous YouTube channels like all family categories, F1, F2, F3, F4, immediate relative categories like spouses, minor children, parents of US citizens, and also our employment categories EB1, EB2, EB3, EB4, and EB5. The easiest way to obtain a green card is to file adjustment of status if you are in the United States in a non-immigrant status. Adjustment of status means you can adjust your status from your non-immigrant visa status to immigrant visa status. This adjustment of status is mainly used for non-immigrant categories, people who are here in America on student visas, H-1B visas, L-1 visas, or people even on visitor visas. If they are eligible, either under the family category or under the employment category, they can apply for adjustment of status. They don't need to go back to their country. They can obtain their work permit and they can obtain their green card. Finally, their applications are adjudicated. But there is a catch. If you are here on non-immigrant status, you should maintain your non-immigrant status until you obtain your green card, which is the safest way to do so, the adjustment of status. But if you are married to a US citizen, or if you are a minor child of a US citizen, or if you are a parent of a US citizen, then you do not need to maintain your legal status both prior to applying for adjustment of status or after filing the application for adjustment of status. Because these categories are called immediate relatives categories, the only requirement for them is they need to enter United States on any non-immigrant categories. Again, for visitor visa people, there is a catch. Under the Department of State new rules, if a person enters on visitor visa with an intention to apply for green card, while here, it is considered as a misrepresentation. For example, if you are a parent of a US citizen entering United States on visitor visa with an intention to applying for green card, like you collect all the documents before you leave your country, the very intention, purpose in entering the United States is applying for green card. It is considered as misrepresentation under the Department of State rules, but US immigration is not following strictly those rules of the Department of State. But it can be a problem because adjustment of status is only a discretionary relief to be granted by the US immigration. Under this Department of State new rules, they prohibited three important things. A visitor visa person cannot apply for green card while here on visitor visa if the circumstantial evidence proves that that person came to America on visitor visa solely for applying for green card. This is true especially for persons married outside the United States then coming on a visitor visa. No, you are not allowed to apply for adjustment of status because it is considered as preconceived intent. But immediate relatives are exempted from this preconceived intent, but we discourage people entering United States after marrying outside United States on visitor visa and applying for green card here. The second important prohibition by the Department of State rule is that if a person entering on a visitor visa cannot seek admission in school or college and change their status from visitor visa to student visa. This is also prevented much before this new Department of State rule by US Immigration that a visitor visa person cannot attend school after filing an application for change of status unless the application is approved. In order to approve an application, it's taking more than 9, 12 months, 15 months. So it is very difficult to enter United States on visitor visa and then change your status from visitor visa to student status. The third prohibition by the Department of State rule is that if a person enters on a visitor visa, that person cannot find a job and change the status to H-1B or L-1 visa or even apply for green card under the employment category. So, if you are on any non-immigrant visa status, like student status, H-1B visa status, L-1 visa status, or PQR, and if you are married to a US citizen, or if you are entering on a visitor visa as a parent of a US citizen, or as a minor child of a US citizen, if you can prove that your intention while applying for the visa or at the time of entry into the United States is not to apply for green card, the easiest way for you is to apply for adjustment of status. After you file an application for adjustment of status, your stay is not considered as legal, but your stay is authorized by the Attorney General. It is called a period of stay authorized by the Attorney General, POSA BAG. We attorneys call it POSA BAG, period of stay authorized by the Attorney General. You will be issued with a work permit. You will be issued with a travel permit also. It's very important to note that once you file an application for adjustment of status, you are not allowed to travel outside the United States until your application for travel permit is approved. Right now, under the new policy, the US Immigration issues travel permit and work permit separately. Previously, they issue a combo card which allows work authorization and also allows travel outside the United States and return to the United States. But since it is taking more than 12 to 15 months to issue a combo card, the US Immigration recently changed the rules. They started issuing work permit within 90 days of filing the application so that the people can stay here and work here legally. So the best thing is, if you are in a non-immigrant category and if you are eligible to apply for green card, which is called adjustment of status, either under the family category or under the employment category, the best option is to file application for adjustment of status. You don't need to go back to your country. You don't need to go back and do the consular processing. But remember, you must be eligible to apply for adjustment of status. There are so many eligibility criteria also. For immediate relatives like spouses, minor children and parents of US citizens, if you cross illegally, no, you are not allowed to apply for adjustment of status after April 30, 2001. But if you came here on any non-immigrant visa, whether you are staying here illegally or you are staying here without any status, you are eligible to apply for adjustment of status. We recommend that you read the description for this video also for more information. And also watch our other videos under family category and employment category to get more information about this eligibility for applying for green card while in United States. Thank you for watching this episode. We appreciate it.